So basically, everyone has been asking me my opinion on the Supreme Court's opinion where they overturned Roe versus Wade and Casey versus Planned Parenthood. And that is in Dobbs v. Jackson Women's Health Organization. And I was like, you know what? I'm not going to do it until I've read the decision. Because there is just so much just fear and panic and invective and everything on both sides, of course. Everyone's just dug in their heels about each of this, when pretty much they're both wrong. And so I was saying, I'm not going to do this until I've actually read the decision, which is really long. It's a long decision and it's a long dissent as well. And so this represents about 5 days of pretty intense work, not just reading, but also like checking out the other precedents and references and things like that. So basically both sides are wrong. One side says, oh no, they've banned abortions everywhere in the country and people are going to die. No, they're not. And the other side says, well, basically kind of the same thing. Yes, they've confirmed that life begins at conception, all that. No, they didn't do that either. We're going to talk about what they actually did cover, and actually use a bunch of quotes, of course, from the decision to actually cover that. But if you appreciate the amount of time and effort that I've put into this, then please go to donate.bogosity.tv and give what you can. I normally don't do the begging for money right off the bat, but this is, like I said, about 5 days of work. There's no way I'm going to make this back from the advertising, everything I've put into it. So if you appreciate all this work, there are several ways to donate: PayPal, crypto, or become a regular. So, alright, so pardon the edits. I probably won't be able to do all of this in one sitting, but let's get into Alito's opinion, which is 79 pages long and very, very wordy. I mean, get a skilled editor. Yeah, working on this, and you can make this a lot shorter, because there's a lot of redundancies, there's a lot of just wordiness. It really should have been a lot shorter. Say what you like about Scalia. The man had his faults, but at least he could write. So, anyway, we'll get into this. This is page 2 of Alito's opinion, which is actually page 10 of the PDF file. And this is one of the annoying things, is they keep restarting the page numbers. So, I'll keep trying to remember to give you the actual page number of the PDF file so you can follow along with it. So, alright, so on page 2, he says, being a misogynist who hates women and wants them to die, I hereby rule... No, I'm just kidding. He didn't say that. Of course he... Although you would think he did from the way some people are talking about this. All right. Seriously. All right. Although the court acknowledged that states had a legitimate interest in protecting potential life, it found that, and they're going to use this potential life language over and over again, because that's what they actually said in Roe and Casey. It found that this interest could not justify any restriction on pre-viability abortions. This viability thing I always thought was stupid, because, I mean, it's just something that the Supreme Court just brought up kind of out of the blue. There was no legislative basis for it. They didn't define it. They didn't really give any guidelines as to what it was, so. The court did not explain the basis for this line, and even abortion supporters have found it hard to defend Roe's reasoning. One prominent constitutional scholar... Oh, my voice is going already. This is not a good sign. One prominent constitutional scholar wrote that he would vote for a statute very much like the one court ended up drafting if he were a legislator, but his assessment of Roe was memorable and brutal. Roe was not constitutional law at all, and gave almost no sense of an obligation to try to be. Now, he cites John Hart Ely in an article in the Yale Law Journal called "The Wages of Crying Wolf: A comment on Roe v. Wade." I'm linking to it below. I hadn't read it before. It's a fascinating article, so you might want to give it a read. I'm not going to go over it, but yeah, it's just a fascinating view from a pro-choice person about why Roe was not a great decision. So, all right, over on page 4. Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin under which states were forbidden to adopt any regulation that imposed an undue burden on a woman's right to have an abortion. The decision provided no clear guidance about the difference between a due and an undue burden, but the 3 justices who authored the controlling opinion called the contending sides of a national controversy to end their national division by treating the court's decision as the final settlement of the question of the constitutional right to abortion. As has become increasingly apparent in the intervening years, Casey did not achieve that goal. Americans continue to hold passionate and widely divergent views on abortion, and state legislatures have acted accordingly. Some have recently enacted laws allowing abortion with few restrictions at all stages of pregnancy. Others have tightly restricted abortion beginning well before viability. And in this case, 26 states have expressly asked this court to overrule Roe and Casey and allow the states to regulate or prohibit pre-viability abortions. So, this is kind of a big difference in kind there. So with gay marriage, that was the Obergefell decision. There was a split among the states, and there was a split among the circuits leading up to the decision. Before Roe, there was none. No state had completely legalized abortion. There was no real discussion in society about it. Some states were kind of liberal on very early term abortions, but it didn't go anywhere near as far as Roe did. And, there wasn't really this big controversy in society like there is today about it. At the time, New York was the state with the most liberal abortion laws. It was passed by Republicans, by the way. Republicans controlled both chambers of the legislature. It was signed by Republican Governor Nelson Rockefeller. But it still didn't go as far as Roe did. And even that triggered massive protests, especially among Democrats. Go figure. They managed to get their legislators to pass a law repealing the abortion law. It only failed because Rockefeller vetoed it. In 1971, 25 states had proposed legislation legalizing abortion. Every single one of them failed to pass. So, Roe was the beginning of the controversy, not the culmination. And what that means is that we never really had this discussion as a society. And what's happened over the last, 40 some years, 50, I guess, actually, since Roe, almost 50, 1973, is that it's just become so heavily politicized and people have, taken up sides against it to such a degree that and it's the fact that we don't really have any sort of deliberative way of managing that, of actually trying to implement that and try to balance the interests of all these different sides. That's kind of what's led to the problem today, because the Supreme Court kind of cut that off right when it was getting started. So, but it's interesting because the way it's generally presented today is, these pro-lifers, they're just religious extremists forcing their morality on everyone else. It wasn't that way at the time. The pro-life movement was about human rights, civil rights, constitution rights, the value of human life, and was a very diverse coalition. So, actually, Alito in this is right. At the time of Roe in 1973, we didn't have this tradition of holding abortion rights as a fundamental human right. But it's also true that, unlike what a lot of people are saying, we're not turning back the clock to 1972. Because now, most Americans support at least some degree of abortion rights, and the legal consequences are going to be very different than it was back then. So, we're not turning back the clock. Remember I have a video, the turn back the clock fallacy. That's, what they're doing. So, it is going to be the case, and we're going to go into this a little more, but it is going to be the case that there are going to be in places a lot more restrictions on abortion, but at least it'll be in a way where, just we as a society can, have a better conversation about it and, probably more, fruitful balances in the state legislatures against all these different interests. So, none of which, by the way, should be, construed as me defending the decision, because remember, I'm an anarchist. I don't want there to be a government at all. I don't want anything banned because I don't want there to be a government around to ban it. But anyway. All right, then let's move on to page 5. This is 13 in the PDF. We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held, and this is going to be very important. The 14th Amendment says that no state shall deprive anyone of life, liberty, or property without due process of law. And so they're saying, okay, the right to an abortion is a part of the liberty part of that, and so they can't deny it. So, that provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. The right to abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. Roe's defenders characterize the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledged, because it destroys what those decisions called fetal life and what the law now before us describes as an unborn human being. So Roe and Casey didn't really do a consideration of the fundamental constitutional basis. They just asserted it was there and gave courts no guidance for how to consider such in the future. And so therefore, page 11 going into page 12, the underlying theory on which this argument rests, that the 14th Amendment's Due Process Clause provides substantive as well as procedural protection for liberty, has long been controversial. And Thomas, as we'll see, will have a lot to say about that. But our decisions have held that the Due Process Clause protects two categories of substantive rights. The first consists of rights guaranteed by the first 8 amendments. Those amendments originally applied only to the federal government, but this court has held that the Due Process Clause of the 14th Amendment incorporates the great majority of those rights and thus makes them equally applicable to the states. The second category, which is the one in question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. And over on page 14, in interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about the liberty that Americans should enjoy. That is why the court has long been reluctant to recognize rights that are not mentioned in the Constitution. Substantive due process has at times been a treacherous field for this court, and it has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives. As the court cautioned in Glucksburg, we must exercise the utmost care whenever we are asked to break new ground in this field, lest the liberty protected by the Due Process Clause be subtly transformed into the policy preferences of the members of this court. So you really have to take care when you give them a power. If you give them a power to do something just because you like it, you also give them that power to do something, even if you hate it. So, what else is this applied to? And an example they give is Lochner v. New York. So this is a decision from 1905. It struck down a New York law setting maximum working hours for bakers, arguing that it violated their right to contract. And that ushered in the Lochner era. The Supreme Court kept making decisions invalidating federal and state regulations of working conditions. The Supreme Court never explicitly overruled Lochner, but it started recognizing more and more state powers to regulate contracts. And it ended with Williamson v. Lee Optical in 1955. That's where they held it in Oklahoma law, saying that only a licensed optometrist or ophthalmologist could fit lenses to a face or duplicate them into a frame. In the unanimous decision, they ruled, "The day is gone when this court uses the Due Process Clause of the 14th Amendment to strike down state laws regulatory of business and industrial conditions because they may be unwise, improvident, or out of harmony with a particular school of thought." So, regardless of what you think about abortion, you have to at least acknowledge how chaotic it would be for the court to just substitute its own morality every time and just call it a constitutional right. The court will just make up whatever rights it wants and impose its own values, which will make them the country's only legislators. Basically, dictators, unelected, for life. Is that really what you want? That can't be seen as a good thing. So over pages 14 to 15, the court must not fall prey to such an unprincipled approach. Instead, guided by the history and tradition that map the essential components of our nation's concept of ordered liberty, we must ask what the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. And Alito mentions that before Roe, there had never been a recognized right to an abortion anywhere in the U.S. It was illegal in all 50 states. Contrast that to the recent gun control decision. There wasn't a history of decisions and writings going back to the founding of the country the way there was with the Second Amendment and gun rights, or even going back to the passage of the 14th Amendment. They had nothing to draw off of. And in fact, abortion was considered illegal not only through our nation's history, but British common law going back at least to the 13th century. And something else you'll see them mention over and over again is this concept called quickening. Quickening is basically when you first feel the baby move in the womb. This was important not because this wasn't like a moral line that was being drawn. They didn't say, oh, it wasn't really a baby, it wasn't really alive until quickening. What they were saying was that there was an evidentiary issue about it. If you didn't have quickening, then how do you know? You have to be able to prove that she's pregnant to prove that she had an abortion. And in the 19th century, they didn't have pregnancy tests. They didn't really have any way to tell. There was no way to prove that in court unless you had a witness to come and say, yes, I felt the baby move. So in 1791, the passage of the Constitution, abortion was illegal. In 1868, the passage of the 14th Amendment, abortion was illegal. And even in 1973, almost all abortions were illegal in almost every state. So there's no state court, federal court, legislature, founding document, opinion of the founders, public opinion piece, legal treatise, or anything else that said that abortion was a constitutional right. Nothing until Roe v. Wade. So, like I said earlier, it was the pro-lifers who were using the language of constitutional rights. Alright, 24 to 25, and this is pages 32 to 33 in the PDF if you got lost. This overwhelming consensus endured until the day Roe was decided. At that time, also by the court's own count, a substantial majority, 30 states, still prohibited abortion at all stages except to save the life of the mother. And although Roe discerned a trend toward liberalization in about 1/3 of the states, those states still criminalized some abortions and regulated them more stringently than Roe would allow. In short, the court's opinion in Roe itself convincingly refutes the notion that the abortion liberty is deeply rooted in the history or tradition of our people. Alright, page 31. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of the various states may evaluate those interests differently. In some states, voters may believe that the abortion right should be even more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Page 32. What sharply distinguishes the abortion right from the rights recognized in the cases in which Roe and Casey rely is something that both these decisions acknowledged. Abortion destroys what these decisions call potential life and what the law at issue in this case regards as the life of an unborn human being. None of the other decisions decided by Roe and Casey involve the critical moral question posed by abortion. They are therefore inapposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. Page 35. Both sides make important policy arguments, but supporters of Roe and Casey must show that this court has the authority to weigh those arguments and decide how abortion may be regulated in the states. They have failed to make that showing, and thus we return the power to weigh those arguments to the people and their elected representatives. So this decision isn't really what either side is saying it is. Like I said at the start, the pro-choice side wanted Roe and Casey to stand. They wanted even better guarantees for future court cases. So it's not what they wanted, but it's also not what the pro-lifers wanted. They wanted the Supreme Court to recognize that the fetus has constitutional rights under the 14th Amendment. They didn't say that either. And since it should not be the function of the Supreme Court to take sides whenever there's such a deep divide among the people, Alito's point is, look, you guys just need to work it out in the state legislatures and lower courts, and maybe we'll revisit this at a later time. Okay, going over to page 37, which is page 45 in the PDF regarding the dissent. The largely limitless reach of the dissenter's standard is illustrated by the way they apply it here. First, if the long sweep of history imposes any restraint on the recognition of unenumerated rights, then Roe was surely wrong, since abortion was never allowed except to save the life of a mother, in the majority of states for over 100 years before that decision was handed down. Second, it is impossible to defend Roe based on prior precedent because all of the precedents Roe cited, including Griswold and Eisenstadt, those rulings about contraception, were critically different for a reason that we have explained. None of these cases involved the destruction of what Roe called potential life. So without support in history or relevant precedent, Roe's reasoning cannot be defended even under the dissent's proposed test, and the dissent is forced to rely solely on the fact that a constitutional right to abortion was recognized in Roe and later decisions that accepted Roe's interpretation. Under the doctrine of stare decisis, and we're going to hear a lot more about that, these precedents are entitled to careful and respectful consideration, and we engage in that analysis below. But as the court has reiterated time and time again, adherence to precedent is not an inexorable command. There are occasions when past decisions should be overruled. As we will explain, this is one of them. So stare decisis means you go by the precedent. And that's something that's traditionally been very important for conservative justices, which is one reason why I was on record saying, like, they're not going to overturn it. Yep, got that one wrong. I got that one wrong. And one of the reasons I thought they weren't going to do it is stare decisis, because they're actually pretty big on that. But of course, they never considered it to be this hard and fast rule that you always go with. He goes on for several pages to say why you shouldn't just blindly go with precedent. So pages 41 to 43. On many other occasions, this court has overruled important constitutional decisions, and we include a partial list in the footnote that follows, which is a really long footnote, and you can look over it yourself. Without these decisions, American constitutional law as we know it would be unrecognizable, and this would be a different country. No justice of this court has ever argued that the court should never overrule a constitutional decision, but overruling a precedent is a serious matter. It is not a step that should be taken lightly. Our cases have attempted to provide a framework for deciding when a precedent should be overruled, and they have identified factors that should be considered in making such a decision. In this case, 5 factors weigh strongly in favor of overruling Roe and Casey: the nature of their error, the quality of their reasoning, the workability of the rules they imposed on the country, their disruptive effect on other areas of the law, and the absence of concrete reliance. Page 44. 52 in the PDF file. Roe was on a collision course with the Constitution from the day it was decided. Casey perpetuated its errors, and those errors do not concern some arcane corner of the law of little importance to the American people. Rather, wielding nothing but raw judicial power, the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Casey described itself as calling both sides of the national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who dissented in any respect from Roe. Roe fanned into life an issue that has inflamed our national politics in general and has obscured, within its smoke, the selection of justices to this court in particular ever since. Together, Roe and Casey represent an era that cannot be allowed to stand. And that might be a good point, because this one decision is the thing that everyone keeps screeching about every time it's time to, appoint a new justice. And it's like this one and only issue is the litmus test, so above all others, above all other considerations. So who knows, at least now there might be some actual debate on how good they are on the Constitution. We can hope at least. Silver lining. Okay, pages 52 to 53. That's 60 to 61 in the PDF file. Oh yes, we're talking about that stupid viability thing. That's the biggest problem I've always had with Roe, like I said. Due to the development of new equipment and improved practices, the viability line has changed over the years. In the 19th century, a fetus may not have been viable until the 32nd or 33rd week of pregnancy, or even later. When Roe was decided, viability was gauged at roughly 28 weeks. Today, respondents draw the line at 23 or 24 weeks. So according to Roe's logic, states now have a compelling interest in protecting a fetus with a gestational age of, say, 26 weeks. But in 1973, states did not have an interest in protecting an identical fetus. How can that be? Viability also depends on the quality of the available medical facilities. Thus, a 24-week-old fetus may be viable if a woman gives birth in a city with hospitals that provide advanced care for very premature babies. But if the woman travels to a remote area far from any such hospital, the fetus may no longer be viable. On what ground could the constitutional status of a fetus depend on the pregnant woman's location? And if viability is meant to mark a line having universal moral significance, can it be that a fetus that is viable in a big city in the United States has a privileged moral status not enjoyed by an identical fetus in a remote area of a poor country? That's a good point. Okay, page 53. The viability line, which Casey termed Roe's central rule, makes no sense, and it is telling that other countries almost uniformly eschew such a line. The court thus asserted raw judicial power to impose, as a matter of constitutional law, a uniform viability rule that allowed the states less freedom to regulate abortion than the majority of Western democracies enjoy. Page 66. Unable to show concrete reliance on Roe and Casey themselves, the Solicitor General suggests that overruling those decisions would threaten the court's precedents, holding that the Due Process Clause protects other rights. That is not correct for reasons we have already discussed. As even the Casey plurality recognized, abortion is a unique act because it terminates life or potential life. Abortion is inherently different from a marital intimacy, marriage, or procreation. And to ensure that our decision is not misunderstood or mischaracterized, even though it is anyway, we emphasize that our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. So all of those people who are screeching, oh, it's going to ban contraception, it's going to ban interracial marriage and gay marriage and all sorts of mean, nasty, ugly things, they haven't read the opinion. Either that or they're lying, because it isn't just here. He hammers it over and over and over and over and over again. How and why abortion is a unique issue. These are so fundamentally different. The arguments he's making just don't apply elsewhere. There's a fundamental difference in kind because with abortion, it has an impact on another life or potential life in the language of Casey. And the rulings are there to set a balance of interests between that life and the rights of the mother. But that's actually a legislative function of the states. That's no purview of the judicial branch. But if you're really worried about that, this is one thing that the Democrats could codify into law. No restriction on abortion should be considered a restriction on marriage or contraception. And they could do that and be consistent with this ruling, as well as other standing Supreme Court precedents. All right, pages 66 to 67. We must address one final argument that featured prominently in the Casey plurality opinion. The argument was cast in different terms, but stated simply, it was essentially as follows. The American people's belief in the rule of law would be shaken if they lost respect for this court as an institution that... Oh boy. You're talking to someone right here who has no respect for courts and judges. They're politicians in robes, people. Right, but anyway. I think it would actually be a good thing if we lost respect in them. But anyway, that's just me. Would be shaken if they lost respect for this court as an institution that decides important cases based on principle, oh, wouldn't that be nice, not social and political pressures. There is a special danger that the public will perceive a decision as having been made for unprincipled reasons when the court overrules a controversial watershed decision such as Roe. A decision overruling Roe would be perceived as having been made under fire and as a surrender to political pressure, and therefore the preservation of public approval of the court weighs heavily in favor of retaining Roe. So he goes on to respond to this, but I think this is an interesting point because what have we seen here? What have the leftists been doing ever since Alito's draft was leaked? I mean, basically everything they did means that the court then had to go with Alito's decision. When you have violent protests, death threats made at Alito, Kavanaugh, and other justices, the court cannot be seen as having caved to the pressure. Regardless of anything else, they don't even want the appearance of anything like that because they don't want to set, a view in the public that, oh, all you have to do is threaten the justices and you can get what you want. So basically, as soon as they did that, as soon as they reacted violently, as soon as they made those threats and so on, they just pooched any chance at a major revision of Alito's draft, any chance at changing any of the justices' minds. That went out the window completely and forever the moment they started doing that. So hope you're happy, leftists. You basically guaranteed this ruling. Yeah. Good work there. Very nice. Oh boy, how long have I been going at this for? Almost 40 minutes. It might be a little shorter after my edits, but we've still got a lot of stuff to cover. I'm only a little more than halfway through my notes, so in the interest of my voice and just keeping these videos somewhat manageable, I'm going to call it a video right here. We'll pick this up. We've got some concurring opinions to cover that are really interesting, and of course the dissent. But for now, you should at least understand what it is the Supreme Court actually decided and what they didn't decide, and we'll get into more of those issues when we come back for part 2. So until then, comments for the Common God, shares for the Share-a-thon, like, subscribe, and the bell. Do that. That gets these videos up in the YouTube algorithms, because this kind of information is something more people need to see and be discussing, because this is exactly what you're not hearing in the mainstream media. You're not hearing it from the pro-choicers. You're not hearing it from the pro-lifers, but it's what they actually decided. So please do what you can. And again, this was 5 days of pretty much constant work, full time. So please go to donate.bogosity.tv and give whatever you can to show your appreciation for that. You've got PayPal, you've got crypto. You can get these videos early and ad-free. I don't exactly know when I'm going to post these. It may be like the start of next week. I may post this one tomorrow. I'm doing this on Thursday, and so the supporters are going to get it pretty much immediately as soon as it's ready. But I'll wait at least a day. But I may, since it's going to be 2 videos, I may put them up on Monday and Tuesday. So if you want to get these videos early and ad-free, you can become a supporter at Patreon or Subscribestar and get other benefits as well. Thank you so very much for watching. I hope you'll join me for part 2. Until then, stay strong and be free.